Καλησπέρα. My name is Loizou and I'm a family law solicitor at the International Family Law Group. Welcome to tonight's programme on Hellenic TV. Tonight we're going to be looking at cases that have a children element, particularly those that relate to child abduction. I'm joined in the studio by my colleague Mandeep Gill, who is going to be talking to us this evening. Over the forthcoming weeks, we're going to be dealing with a number of other topics to include divorce, finances on divorce, other children topics to include where parents wish to permanently relocate to another country, also cases that involve court proceedings, how you resolve your disputes if you are in court, and also looking at how we resolve cases without needing to go to court. We're also going to cover a number of different topics. Mandeep is a solicitor at the firm, and she deals with the children work, and particularly those cases that have an international element. Mandeep, welcome to the studio.
Thank you.
We're going to be running through a number of questions, general questions in relation to this area that Mandeep is going to answer, and she's going to be giving our viewers some guidance and tips in relation to this area. So let's begin. Mandeep, if you could tell us, what is child abduction?
Well, there's two types of child abduction. One is stranger child abduction, and the other is parental child abduction. I'm not going to be looking at stranger child abduction because that's a criminal law matter, and therefore I'll be just discussing the family law aspect of child abduction, which occurs when one parent unilaterally removes a child internationally from one jurisdiction, one country to another country, or they take the child on holiday and don't return the child back at the end of that holiday period. It's usually there's an element of no consent from the other parent, and as I say, it's a unilateral decision that one parent makes, which they're not entitled to do, regardless of whether that parent is the primary carer of the child, usually looks after the child, or has sole care of the child.
And what is the Hague Convention, and how does that connect or relate to child abduction?
The Hague Convention is an international agreement, and it came into force in 1980. The UK has been signed up to this agreement since mid-1980s, and it's signed up by about 80 countries. And it basically gives parents a uniform way of dealing with a child abduction situation. So what this international agreement does is recognise that it's in the child's best interests and in the child's welfare to be returned back to the country that they've been taken from, for any dispute about that child to be dealt with in that country, and therefore it gives parents a remedy and a procedure to follow to try and recover the child. Lots of countries, as I say, are signed up to it, about 80, and for the Greek viewers, Southern Cyprus and Greece are two of the countries that are signed up to it. Along with all the sort of very large countries, as you would expect, America, Canada, Australia, and most of Europe.
And how does an abduction occur under the Hague Convention?
Well, there's two types of abduction. One is a wrongful removal, which is a situation of an outright abduction, where the parent takes the child internationally without any notice or consultation with the other parent, or without the court's permission. So that, as you would imagine, is the worst form of abduction from the other parent's point of view, because it is a very sort of sudden thing to happen. The other type of abduction is called a wrongful retention, and that usually is in a situation where one of the parents has taken the child on a holiday abroad for a set period of time, and that parent fails to bring the child back at the end of the holiday period, or it could be some other temporary arrangement for the child to be away from the home country, and the parent deciding unilaterally not to bring the child back. So that would be in breach of the other parent's rights, and it would mean that that parent would obviously have a remedy if the country that the child is being held in is signed up to this international treaty to try and recover the child. And the important element for parents to remember and viewers to remember is that the child has to be settled in the original country and living there, so have a well-established home. It's the child's main home there, so attending school and everything else, and we usually call that habitual residence, but that essentially, as I say, is just the important element of the child being settled in that country, regardless of the child's nationality. So if a child is removed from England but is of Greek origin, nationality, then that does not prevent the child being recovered back here. The important element is that that child should be settled in this country in order to try and take steps to recover him or her back here.
And if a child's been abducted, and it's one of the Hague Convention countries, what does the process entail? How do you get the child back? How is the child returned? How does that work?
So if we are talking about a child that's been taken outside of the country, so away from England and Wales, then what you should do as a parent, if you find yourself in this position, is to contact the what's called the Central Authority. Their specific name is the International Child Abduction and Contact Unit. They're based in London, and you would need to contact them to start the process off of making your application under this international agreement, and they would sort of transmit your application on your behalf. Some people go directly to the Central Authority, other people go through them via a solicitor, so either way is acceptable. Some parents would like help from a solicitor to complete the application form. Others do that part of the process themselves. But the important element is to go through the Central Authority, who will then transmit the application to the Central Authority and their counterparts in the other country. And if we're talking about a child being removed into this country, then the Central Authority in this country will also be involved, and their role is reversed in that they will receive the application in from the Central Authority of the country that the child has been removed from, and they would be essentially their first job would be to appoint that particular parent with a lawyer, a specialist international child abduction lawyer, to run the case for the parent. And at that point, the lawyer generally will make direct contact with the parent and speak to the parent to begin the court procedure. And most of the time the parent doesn't need to travel into England to take part in court proceedings. The solicitor generally can attend hearings and deal with the matter without physical attendance being needed by the parent.
And is legal aid available to parents who find themselves in this situation?
Yes, if the application is made under this international agreement, and a child is brought into this country, then that parent who makes the application to recover the child back would get automatic legal aid. There would be an entitlement to means and merits tested legal aid, which means that even if we're talking about the most wealthiest person, they would qualify, and they don't need to go through the usual hurdles of proving to the Legal Services Commission, who are the legal aid board, that there's good merits to the case. So it's a very sort of quick process in order to get legal aid, and all that's required from the central authority is a letter to the person's solicitor instructing them and appointing them to act, and that solicitor would use that letter to get very quick legal aid for the applicant parent. If we are talking about the respondent, so the person I suppose you would class as being the parent that's abducted the child, then they may qualify for legal aid. It depends on their personal circumstances. It's not automatic as it would be with an applicant parent. That parent would have to show what their means are and the merits of their case, and if they meet the criteria, then they would qualify for legal aid, and that is something that their lawyer would put into place for them and apply for them. Otherwise, they would need to fund their own legal fees, or think about other ways of defending the application if that's what they want to do, such as representing themselves.
And I mean, no doubt quite often you hear parents who say, I did this for a reason. Are there any defences to child abduction under the Hague Convention?
Yes, there are. There's limited defences. They are very difficult to establish in most cases, and when children are abducted into this country, most cases do result with the child being sent back to their original country. But that having been said, there are defences, and I'll run through them very briefly. The first defence is the defence of consent, which is sometimes raised by a parent who's trying to defend the application on the basis that the other parent consented either to the removal, if it was an outright removal in that way, or to the child remaining in this country beyond, for example, the holiday period. And if consent can be shown, then that will be a complete defence to the applicant parent's application for a return of the child. In those cases, sometimes oral evidence is needed in court, which means that the parties give evidence under oath in court, and video links can be set up for the applicant parent if they're living abroad and can't attend. So those cases are the very sort of limited cases in which these issues of having to give oral live evidence in court occurs, and as I say, most of the time you can set up a video link so that the parent doesn't have to travel into the country, unless of course they wish to, or there's some other practical reason why they should physically attend. And then the other defence is a similar defence, and it's called acquiescence, and that is a situation where the respondent parent who is seeking to defend the application to try and keep the child in this country claims that the other parent, the applicant parent, may not have consented to the removal or the retention in the first place, but has since, by his actions or words, accepted the situation so that the child can remain here. So
what type of actions or words might that be? Just by saying you can stay?
Yes, I mean, it can be a sort of retrospective consent, if you like.
Okay.
You know, it's a very difficult defence to try and run because you really do need very, very clear words or action from that parent showing that they have consented retrospectively for the child to remain here. So it can be various things. It could be emails between the parents in which words are said that the respondent parent has construed as giving them authority to keep the child here. Or it can be things, physical things, such as the applicant parent shipping over goods for the other parent to make their life a bit more comfortable here, and thereby helping that parent remain here with the child. So it can be you know, any number of things depending on the case and the circumstances, but the most important thing to remember is that it has to be very clear actions or words, and for that reason it's quite a difficult thing to show. And again, this is one of the very few defences where you may need the parties to give oral live evidence in court. And then another defence is the defence that we call child's objections. And this would be a situation where the child is said to be strongly objecting to going back to the original country. Now, as you can imagine, it will all depend on the child's age. And one of the criteria is the child needs to be mature enough to form these objections. Also, the court will be wary of children saying certain things, but not those things not forming genuine objections. So what would normally happen is that if a defence like this is raised by the parent that seeks to remain here, then the court will appoint what's called a Kafkas officer, who is like a welfare officer, to speak to the child, to try and find out what the child's wishes and feelings are, and whether that child is mature enough to found strong objections. And the Kafkas officer, the welfare officer, will do a report to the court, summarising, you know, the meeting that they've had with that child, and any recommendations that they can make to the court. So the welfare officer is like the eyes and ears of the court, if you like, because most of the time the child is not seen by the judge and is not involved in the court hearings. So this is the way that the court establishes if there may be a child objection point. And if on the face of this report that the court receives, it appears as if the child is objecting, then the Kafkas officer usually is required to come to court to give some evidence to the judge and a bit more detail about the meeting that they've had with the child. So generally the child needs to be of a sufficient age where it can be reasonably argued that the child is mature enough to have these objections. So, you know, a child from 9, 10, 11 onwards generally will be interviewed if this defence is raised. Sometimes children even younger, much younger than that. But if we're talking about children, you know, below the age of 5, then it's probably not going to be, you know, a defence that's going to be open to the parent to run. And then the next defence is the most commonly used defence by parents that want to remain in this country, and that defence is known as the defence of intolerability, and this is used by parents in quite a wide way. In that parents will say various things, make it intolerable for them and in turn for the child to go back to the original country. generally speaking, if it's relevant at all, parents allege that there's been some sort of domestic violence situation in the original country, and that if the child was sent back by way of a court order, then if the parent was to go back with the child, it would expose them all returning back to that intolerable situation. So that's the most common thing that most respondents allege in these cases. It's a very difficult defence, and the bar is very high for it to be successful, and most people fail in showing that this defence is made out. But it's not just domestic violence. You know, people allege all sorts of things, such as they don't have housing, for example, back in the other country. They may have given up the housing that they used to have there because of the move here, or that they don't have jobs or money to make it viable to go back, whereas they may have family or friends that can help them here, or they may have even secured new jobs here. So they're more practical things and quite common things that parents do allege, but generally those practical things are things that the court can address somewhat to make the return possible, by asking the applicant parent to give certain promises to the court to help the parent go back. So, for example, money for rent, child maintenance, things like that. So the practical issues can be addressed, and usually, in most cases, that means that a return is ordered. And then very lastly, there is the defence of settlement, which is a situation where a child has been in this country, or whichever country they've been taken to, for more than 12 months, and they are settled here, and that as a result of that situation they should not be caused to go back and should not be ordered to return. So it is a 12-month cut-off point. So from an applicant's point of view, any application for the child's return should be made as soon as possible, and well before this 12-month period comes into play. Otherwise, this is a defence that's potentially open to the other parent to try and run, because as you can imagine, if 12 months or more have gone by, then the child will be at school and have some sort of established routine, and all those things at that point become very much relevant, and that is a defence that potentially could be used successfully to try and keep the child here. And
I can imagine that this period is very stressful for both parents. If you're within the court process, how long does it take? You know, is it a matter of days, weeks, months until a decision is made? What's the time frame?
Well, thankfully, the international agreement that we've been talking about, the Hague Convention, has a time limit within it, and it specifies that technically the application should be dealt with within 6 weeks of it being issued with the court. So that's a relatively quick turnaround time, really. And here in England, all the applications are dealt with of this nature by the High Court in London. And because it is a very centralised system that we have in this jurisdiction, in this country, we generally do stick within that time limit, and the application generally is dealt with within 6 weeks. Other countries don't have such a centralised system. It may not be possible because of the the own court system that they have in place, and therefore it might not be possible to keep within this limit, but that is technically what the agreement says, and that's what we always try and aim for. So time is really of the essence when listing hearings and trying to manage the case, and think about what needs to be done to prepare the case for a final conclusion.
And do you ever come across a situation where a client just says to you, I just don't know where my child is, what am I going to do, how are we going to track them down? Do you come across that generally, and what do you do about it if it does happen?
It commonly happens that a parent, for one reason or the other, thinks or knows that the child is in this country but doesn't know exactly where, and they can't pinpoint even a town or city, but for some reason, maybe through friends or family or some sort of information that they've got in the country that they live in, such as information from an airline or the police, know that the child's here or has been here at some point, but doesn't know precisely where. So as I say, that's not an uncommon situation. So there are ways of trying to track the child down, and generally these methods that we use to locate a child are very successful in the majority of the cases. So what a solicitor in that situation can do for the parent that wants to try and find the child is get orders from the court to various people or organisations for disclosure of information about the child's whereabouts. So, for example, if there is a telephone number that's known to us for the parent that's brought the child over here, we can get orders to the telephone provider, the telephone operator, to provide any address details that they might have for their customer, and also, if needed, provide us with copies of telephone bills, so we can pinpoint, roughly where the phone has been used, what city, etc. That in a similar way, we can do that with bank accounts that somebody might have. So sometimes a parent knows of the bank that the other parent uses, or they have the actual account details, and with those details we can convince the court, usually in this situation, to order for that bank to provide us with information that would help for us to establish the child's whereabouts. So that's a very useful order to get, because as you can imagine, if we've got copies of somebody's bank statement and they are withdrawing money, then we can pinpoint where they have been using their cash card, their bank account in that way. So there's various, as I say, disclosure orders you can get. Those are just two examples. We can get orders against government departments, because most people are registered with some sort of government department in one way or the other. For example, they're registered with a GP, or they might be registered to claim benefits. So that there are avenues in that sense that we can pursue. If we know which airline somebody has travelled into the country with, then we can obtain orders against that airline to provide us with any information that they might have, and that's proved quite successful in many cases. So there's lots of orders that people wouldn't normally think are possible to obtain, because they are basically orders that override the usual rules about data protection. But if there's a High Court order in that way, then the person or the organisation that the order is made against is obliged to give that information, although ordinarily it would be confidential information. You can also obtain what we normally call freezing orders. So if we think that by freezing somebody's bank account, for example, they may surface, or there's a way of making them engage with court proceedings, then that's something that can be done as well. It depends on the circumstances, and it depends on what assets that person has got.
And just to conclude our programme for today, can you offer any practical tips to parents if they think that there may be a child abduction, it's about to occur? What can they do? What should they do?
There are things that can be done. and some of them involve going to court, some of them don't. Obviously, from a practical point of view, a parent that's fearful of this situation can hide the child's passport if they know where it is. So that's just a very quick thing that possibly a parent can do. The other is to inform the school, not to be vigilant and careful about who is collecting the child at the end of the school day, and the school can be directed to not allow the child to go home with anyone other than with that particular parent. The other route to try and safeguard the situation is by going to court and obtaining various orders. Somebody can, for example, in that situation, apply for what we call a prohibited steps order, which essentially prohibits the other parent from removing the child out of this jurisdiction, so out of England and Wales. The other type of order that can be obtained is a passport order, which can be obtained through the High Court here in London. And what that would involve is that the enforcement officer of the High Court would be directed to try and seize the passport of the child and also of the parent that is believed to be the one that is attempting to remove the child from the country and abduct them. So that's quite a powerful type of order to obtain. And then one other thing that can be done is through either the police or the court, what's called a portalet can be put into place, which would essentially mean that all the ports, so all the different avenues of leaving England and Wales, would be alerted that there is a very high risk of the child being removed without the other parent's consent. So that's something that can be done, and it's essentially putting the child's details on a type of database to prevent the removal from taking place. And as I say, that's something that you, a parent in this situation and in this fearful situation, can obtain through the police if it can be shown that there's a real and imminent threat of an abduction, or through the court as an alternative.
Mandeep, thank you. That's really good guidance there for our viewers and some good practical tips.
Thank you.
So really, just to conclude today's programme, we've been talking about child abduction. It's a very complex area of the law, and I would say to all of our viewers, if you have these concerns, make sure you get specialist legal advice early on. It's very, very important. Don't leave it too late. At our firm, we have specialists that deal with these types of cases day in, day out. So do take advice. Both Mandeep and I, as I say, we work for the International Family Law Group, who sponsors this show. We are based in Covent Garden, and we're a niche specialist practice, and we provide family law services for both clients that are national but also international. So if you do have any questions in relation to family law, please don't hesitate to contact either myself or Mandeep, and we'll be happy to help. Our telephone number is 0203 178 5668. Please also feel free to have a look at our website, www.iflg.uk.com. So that concludes our show for today. Mandeep, thank you for joining us in the studio. We'll be back again next week. And Galiniktasas, Ευχαριστώ.